Good morning and once again welcome to Criminal Law 1, Articles 15 to 20. We have learned that there are a lot of circumstances such as mitigating and aggravating circumstances. Now in this topic we are going to deal with the alternative circumstances, which it could be either mitigating or aggravating circumstances. Article 15, their concept. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other conditions attending its commission. They are the relationship, intoxication, so you have to take note with these words. Relationship, it could be intoxication, and the degree of instruction and education of the offender. The alternative circumstances of relationship shall be taken into consideration when the offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. So you have to take note if it is in a relationship. Huh? And then in the intoxication of the offender, now an intoxication of the offender, when you talk about intoxication, yung pagkalasing, di ba? Shall be taken into consideration as a mitigating circumstances. But you have to take note, when the offender has committed a felony in a state of intoxication, if the same is not habitual, kung hindi siya habitual, or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as aggravating circumstances. So you have to take note that if it is not habitual, it could be one of the mitigating circumstances. But kung habitual na siya, ang iyang intoxication, palahubog kayo siya, and it is intentional to commit a felony, then it could be considered or categorized as aggravating circumstances. Next, we have, now what are the three alternative circumstances? So as mentioned in the article, that they are relationship, intoxication, and the degree of instruction and education of the offender. The relationship included are exclusively that of spouse, ascendant, descendant, legitimate, natural, or adopted brother or sisters, or relative by affinity in the same degrees. So other as step-parents and step-children are included by analogy, but not uncles and nieces. You have to take note, not uncles and nieces, for there is no mention of relatives by consanguinity other than those enumerated in article. So you have to take note that this is an exclusive, meaning to say nga kung ibig sabihin kung in terms of relationship, diri lagi ta magtutuyok sa spouse, ascendant, until sa step-parents and step-children. No, but there are limitations. No? When is relationship aggravating and when mitigating? Now, the revised penal code is silent as to when relationship is mitigating and when it is aggravating. So, kano sa siya nga na-mitigate ang crime and kano sa siya nga nag-aggravate ang crime. In crimes against chastity, such as acts of lasciviousness, relationship is aggravating, no, because there is undue influence to the victim. For example, a father, no, na-commit o kanang acts of lasciviousness, there is undue influence on the part of the victim. For example, ang victim is minor. Oh, she could not decide for herself, no, because they are vulnerable. That is in the People versus Marino. It was decided last January 18, 2001 by the Supreme Court. However, rape is no longer a crime against chastity, but a crime against persons. Still, relationship is aggravating in rape. Kung ang ni-rape is ay ang kadugo like father or his stepbrother, no? So it could be an aggravating circumstances kung brother or sisters niya or na sila relationship, a family relationship, I mean. Article 264 provides that if the injury is inflicted upon the father, mother, or child, other ascendants or descendants and spouse, the penalty shall be 1 or 2 degrees higher. So imagine that, 1 or 2 degrees higher. So kung mapriso ka nga 15 years to 20 years, so 1 degree higher, kasi maabot na ka 30 years na imprisonment. Now, except when committed against the offender's child due to excessive except when committed against the offender's child due to excessive chastisement, in which case it is not aggravating. Okay. When is intoxication mitigating and when aggravating? So, paano natin masasabi ng intoxication is mitigating and when aggravating? Now, a person pleading intoxication as a mitigating circumstance must show that, first, he has taken a quantity of alcoholic beverages prior to the commission of the crime sufficient to produce the effect of obfuscating reason. Second, he is not a habitual drinker and did not take the alcoholic drink with the intention to reinforce his resolve to commit the crime. So to have a further illustration with regard to the intoxication as a mitigating circumstances, we have the case of People versus Pinca. Now, the offender's mental faculties must be affected by drunkenness. Mere drinking of liquor prior to the commission of the crime does not necessarily produce a state of intoxication. It is mitigating if it is not habitual. So you have to take note na magiging mitigating lamang ang intoxication if it is not habitual. Ibig sabihin, dili kad adlaw, di araw-araw. As opposed to the habitual, it is just an occasional. No? Kung nalay mga birthday, dito lang ka mag-inom. And not intentional. And self-control is diminished as a result of intoxication. So nawala yung self-control. Diminish. Otherwise, it is aggravating. So if there is no presence of these factors, then it is aggravating circumstances. Therefore, an alcoholic who commits a felony while intoxicated will always suffer from these circumstances because either habitual or intentional intoxication will suffice as the law used the disjunctive or inhabitual intentional. But you have to take note na it is just only an mitigating circumstances. Hindi ibig sabihin na kung mitigating circumstances, you are exonerated from criminal liability. Andyan pa rin yung criminal liability, but it is just mitigated. No, basig you misinterpreted the provision na kung mitigating, wala nang kaso. Andyan pa rin ang kaso, but it is just that it was mitigated by these circumstances. Persons criminally liable for felonies. Article 16, who are criminally liable. The following are criminally liable for grave and less grave felonies. So they are categorized as a grave and less grave felonies and light felonies. Now here, there are three category of persons who will be criminally liable in the grave and less grave felonies. Number 1, the principals or the author of the crime. Number 2, accomplices. And number 3, the accessories to the crime. Now we have also here a criminally liable for light felonies, such as there are some certain cases, in certain cases of theft, the simple theft. So only the principals and accomplices are liable for the felonies committed. Next, we have here Article 17, the principals. Who are the principals of the crime? So the following are considered principals. Number one, those who take a direct part in the execution of the act. Number two, those who directly force and induce others to commit it. So whether you are not have a direct participation, but you force or induce others to commit that such kind of crime, you will be considered as principals. Those who cooperate in the commission of the offense by another act without which it would not have been accomplished. So without your inducement, without your force, without your supervision, the crime would not have been accomplished. So since you are the author of the crime, you will be liable and punishable as principals. And you have to take note that principals, accomplices, and accessories have a different category of penalties when it comes to the uh, violation of the different crimes committed. Okay? Must the principal by inducement appear at the scene of the crime? So, kailangan ba talaga na principal by inducement appear at the scene of the crime? Now, the answer is no. Principals by inducement or the mastermind, you're just only the, you plan everything and you are the master of that plan, are liable even if they did not appear in the scene of the crime because the crime would not have been committed without the inducement. And that is why they induce others to commit the crime. Example, you are so mayaman, diba? And you have a lot of bodyguards, and you have a lot of killers, no, that surrounds you, and you induce them to do such crime. Technically, you are still the principal author of the crime, even if you are not in the crime scene. The fact that it was a mastermind and not petitioner who dealt with directly with said fixer. So here there is a case, no? The fact that it was MMM and not petitioner who dealt directly with said fixers cannot exculpate petitioner from the charge of the falsification. So MMM. So technically, he is a principal by inducement in the commission of the said crime. We have here Article 18, accomplices. Accomplices are those persons who, not being included in Article 17, cooperate in the execution of the offense by previous or simultaneous acts. Now the question is, in conspiracy necessary for the liability of an accomplice? So you have to take note that conspiracy, these are the two or more persons gathered each other to commit a crime, or they plan to commit a crime. No, it is not necessary, for he is not a principal, but he supplies material or moral aid to the principal in an efficacious way, and he knows of the criminal design of the principal and it cooperates knowingly or intentionally, but in a manner not indispensable to the commission of the crime. Otherwise, he will be considered a principal by indispensable cooperation. It doesn't necessarily that there is a conspiracy for a person to become liable of as an accomplice of this crime. Though you did not kill that person, but you participate in the killing of that person. Without you, it could not be accomplished. The crime would not be accomplished. Article 19, accessories. These are those who, having knowledge of the commission of the crime, and without having participated therein, either as principals or accomplices, take part subsequent to its commission in any of the following manners. Number one, by profiting themselves or assisting the offender to profit by the effects of the crime. Number two, by conceding or destroying the body of the crime, or the effects or instruments thereof, in order to prevent its discovery. Like you're going to destroy the body, like burning the body of the said victim. So you could be an accessory of the crime, and whether you like it or not, the penalty depends on the main crime committed by the principals. So it depends upon the commission of the crime. Third, by harboring, concealing, or assisting in the escape of the principals of the crime, provided the accessory acts with abuse of his public functions or whenever the author of the crime is guilty of treason, parricide, murder, and attempt to take the life of the chief executive, or is known to be habitually guilty of some other crime. So they will be considered as accessories of the crime. So if the mentioned provisions are accomplished. How do accessories profit by the effects of the crime? Now, a person who received any property from another and used it, knowing that the same had been stolen, is guilty as an accessory because he is profiting by the effects of the crime. Minsan pag wala, you did not inform, you are not informed, no, kaning for example, kaning motor, gibaligya sa imo, and this is a stolen motor vehicle. Now, you are still guilty as an accessory because you are profiting by the effects of the crime. Kay baligya lang siguro kanang less, no? Mas gamay ang pagbaligya compare sa katong yung assessment value. Now, by employing the carabos in his farm, there is a certain case. TTT was profiting by the objects of the theft. TT has knowledge of the crime and yet without having participation. So again, TT has knowledge of the crime and yet without having participated either as a principal or as an accomplice, for he did not participate in the taking of the carabos. He took part subsequent to the commission of the act of taking by profiting himself by its effect. Technically, that is not allowed. So TT is an accessory after the fact. So kung alam niyo na nakaw lamang ang mga kagamitang iyan, you have kung hindi, if you did not compel them to return such thing, then wag ka nang sumali. You should not buy that such kind of the Article 20 accessories who are exempt from criminal liability. Okay, the penalties prescribed for the accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with the single exception of the accessories falling within the provisions of paragraph 1 and the next preceding article. Okay, we have here oral recitation on Article 16. I'm going to upload link on the Google Classroom. Then you're going to upload all your videos there containing your oral recitation, and you have to close your eyes, of course, when reciting the provisions of the law. And upload a video within this day before 12 midnight. Please also memorize the provision by heart for your own benefit, because if you're just memorizing it without comprehension, it will gonna be useless. Okay, thank you so much.